Your Excellencies, the principle of nationality is recognized by the ILC diplomatic protection under Article 7, which practices on dual nationality, which the state with the predominant nationality has to be the one who brings the diplomatic protection over the person, Your Excellencies. And in the present case, we argue that.
But isn't that in cases where the two states are facing each other, where there are a dispute concerning those two states?
Respectfully, Your Excellencies, in the Notapum case, such cases are not required, as in the Notapum principle, there was no contention between the third state and the other state of nationality between who may.
You mentioned the Notabum case, but the Notabum case has been criticized by the Flagenheimer case and also the ILC, citing that it in the contemporary society, considering that the Notabum case was made years ago, in contemporary society, it is no longer viable. Millions and millions of people will be deprived of the right to be protected under diplomatic protection. As a court, we should also consider this. Don't you think so?
Respectfully, Your Excellencies, those are against this principle is arguing it in regard to its application of diplomatic protection where the person has a single nationality. However, in the present case, Mr. Natote has a dual nationality, therefore will not be excluded. And on your concerns of the principle being outdated, such principle is still relevant in international law and has been recently cited in the 2019 reports by the European Commission as a standard for acquiring nationality in the international arena. Therefore, Your Excellencies, this principle still applies and proves that the applicant does not have legal standing to bring a claim on the basis of diplomatic protection to Mr. Natote, and its claim must, for this reason, be held to be inadmissible. If I may continue to the second legal standing based on erga omnes. Your Excellencies, erga omnes are obligations of a state towards the international community as a whole, which arises out of jus cogens norms. Recognized erga omnes obligations are
Wait a second, Council.
Oh, sorry. Council, sorry. Does it always have to be jus cogens norms?
Your Excellencies, it is recognized in the ILC Special Rapporteur by Gerald Tadic on the jus cogens that jus cogens give effect to erga omnes obligations, and that is the standard that we are bringing it on.
And so jus cogens give effect to erga omnes obligations, right? But that doesn't mean that erga omnes obligations are only exclusive to jus cogens norms.
Your Excellencies, it is not to my knowledge if such cases, but in the personal attraction case, it is also consistent that jus cogens norms is the one that brings effect to erga omnes obligations, and that is our argument.
Here's the thing, Council. 2 points. First of all, the personal attraction gives examples of what erga omnes norms are. And secondly, in the court's decision on the Timor-Leste case, the court cited that the right to self-determination is also erga omnes. What do you have to say about this? That's not necessarily jus cogens, is it, Council?
No, Your Excellencies. However, the principle of erga omnes itself has to be seen in a high standard set as demonstrated in several cases like the nuclear test case and in the South African case.
And the nuclear test case is about the environment. We're talking about the environment here. Yes,
Your Excellencies. It is said that in the dissenting opinion of such case, it is said that the erga omnes obligation has to be seen in cum grano salis, or with a grain of salt. Therefore, there is a high standard in accepting it, and therefore we're bringing this strict.
Okay, Council. So you're bringing your argument based on separate opinion, while the opposing counsel, the applicant, bring the entire advisory opinion. So do you have any other supporting ground so your argument can be prevailed?
We have legal basis also under Article 48 of the RCWA, Your Excellencies. If I may proceed.
What did it say? 58 of RCWA?
Your Excellencies. The Article 48 of the RCWA, it stated that erga omnes obligations are the legal interest of the whole international community, which arises out of the preemptory norms, which is cited in Article 42 of the RCWA, which is likened with jus cogens norms, Your Excellencies. If I may proceed.
Council, entertain us with this hypothetical situation. A country sends its tanker into the high seas in the middle of the Indian Ocean and deliberately start spilling oil everywhere, then she's responsible. Because if we take your interpretation, it's no one's territory, it's no one's land, then no one can be held responsible.
Your Excellencies, respectfully, in such cases, the state can be held accountable, but just not under erga omnes obligations. It may be held accountable under other obligations, such as.
Then what standing can any state bring against in such circumstance, if not erga omnes?
Your Excellencies, I am unable to answer your question. May I proceed with my argument? Thank you, Your Excellencies. Proceeding to my argument on erga omnes. So pursuant to Article 48 of the RCWA, an erga omnes obligation has to be accepted and recognized by the international community of states as a whole, from which no derogation is permitted, whereby the norm is upheld by states on their own without the need of bilateral agreements. Your Excellencies, while the prevention of transboundary harm is regarded as important by the international community, it is not elevated in the sense of jus cogens. Owing to the fact that failure to prevent transboundary harm is not a non-derogable right under Article 4 of the ICCPR, and additionally, the obligation to prevent transboundary harm is most often tied to bilateral treaties and functions, and not something that states acknowledge on their own. Moreover, there has not been sufficient time to enable this issue to evolve to the status of jus cogens norm. This is in contrast to recognized jus cogens with erga omnes effects like genocide, which have been recognized as a legal interest by the international community as a whole since 1951. Lastly, Your Excellency, as of now, the court has yet to accept a legal standing based on erga omnes obligations. Therefore, even if failure to prevent transboundary harm is considered to have jus cogens, it's considered to be jus cogens and have erga omnes effects, its acceptance as a standing.
Counsel, sorry, Daniel.
Hear me, agent? I would like to ask, does the ILC article on state responsibility contain a reference to jus cogens?
Yes, Your Excellencies. It refers the Article 48 refers the Article 42, which guides the norms for jus cogens. If I may continue. Yes, Your Excellencies. Article 48 refers to Article 40 of RCWA, which guides the jus norms.
Norm. Jus cogens refers to primary norm, but I don't think you've convinced this bench about the requirement that this obligation be a jus cogens norm. Do you have any other arguments?
Your Excellencies, ILC articles by the Special Rapporteur Jus Vladik in the first report, it is mentioned that jus cogens norms gives effect to erga omnes obligation, and that is the standard that we bring it upon, Your Excellency.
Is the contrary true? Does erga omnes have to be jus cogens? Jus cogens give rise to erga omnes in legal interest in international community, but is the reverse true?
Your Excellencies, I'm not aware of such principles, and even if that is the case, we still submit that the prevention of transboundary harm is not the legal interest of the international community as a whole, since it is often tied to bilateral agreements, Your Excellencies. If I may continue to my submissions.
Counsel, let me ask a question on the merit. The obligation to prevent transboundary harm, especially on the diligence, covers more than just before the project is initiated, but after the project is initiated. Is there any indications in the statement of agreed facts that your client has done this? You can have 1 minute to answer and then conclude.
Your Excellencies, under the obligation of due diligence, this obligation is an obligation of conduct and not an obligation of result. It is not intended to guarantee that there is a significant harm be totally prevented, and we submit that the respondent has fulfilled the obligation to conduct in the environmental impact assessment as referred to in the order in paragraph 18. Furthermore, Your Excellencies, regarding
My question is not before, my question is after.
Your Excellencies, regarding the obligation to conduct an environmental impact assessment after the earthquake, Your Excellencies, according to Principle 17 of Rio Declaration and the ILC draft articles on prevention of transboundary harm, the EIA is a national instrument that is subject to a decision of a competent national authority. Therefore, in regards to how often or how RIALA conducts its environmental impact assessment, it is up to their national law to decide. Therefore, no contentions can be brought up by the court or by the applicant state in regards to this. And if I may conclude my submission, if there are no further inquiries, therefore, Excellencies, we submit that the applicant does not have
a question, which is really interesting to me, that you've stated that it is up to your national discretion to determine the EIA scope, but the effect of such damage was actually international. So is it actually wise to let the national take control of something that could affect another state without any cooperation?
Due to the interest of time, do I have extra time to answer this question, Your Excellencies?
Answer and then conclude. Just answer.
Your Excellencies, regarding the pollution because it reached the high seas, Your Excellencies, it may be held liable to the Lexa Energy itself and not to the state, as the act of the RIALA here is. The act of Lexa Energy is not attributable to RIALA, as RIALA is not RIALA is not controlling the acts of the corporation in regards to the strict principle test brought up in the Nicaragua judgment. Your Excellency, and if I may conclude, therefore, Your Excellency, we submit that the applicant does not have legal standing under both diplomatic protection and erga omnes, and furthermore, RIALA is not responsible and has fulfilled its obligation to prevent transboundary harm, and consequently, as they did not commit an internationally wrongful act, they should not pay compensation to Andel. If the court has no additional inquiries, this agent has finished her submissions and hope that the court will be in favor of the respondent. Thank you, may it please the court.
Thank you, counsel. Now the second counsel of the respondent, whenever you're ready.
Okay. Am I audible?
Yes, counsel.
Very well. Okay, so. Good day, Mr. President, Your Excellencies, and may it please the court. My name is Vincentius Alexander, pleading on behalf of the Democratic State of RIALA, the respondent in the present case. For the following 12 minutes, we'll be submitting our submission that the cyber attack conducted by the respondent did not contravene the international humanitarian law. Mr. President, Your Excellencies, may it please the court. Your Excellency, pursuant to paragraph 1 of the clarification, both parties agree that we will not contest the attributability before this court. Therefore, this agent shall continue by submitting the justification of the cyber attack, which was justified for two reasons. First, the cyber attack.
Counsel, before you continue addressing the IHL violation, do you concede to the applicant's submission that there is non-conflict situation in this case?
Yes, Your Excellency, simply for the reason that the cyber attack was conducted during an ongoing conflict, which articulated in several paragraphs of the order, such as the paragraph 31, 33, 36 of the order, where such paragraphs express the escalation and the development of the Gulf hostilities. And furthermore, pursuant to paragraph 70 of the ICTY study case, the international humanitarian law applies whenever there is an armed conflict. Therefore, we submit there is an armed conflict in the present case, and our cyber attack constitutes the use of force. However, we submit that our cyber attack is lawful in the present case.
Yes, question. You brought the point of Tadic case in which it is ICTY. Has the court ever cited ICTY in this previous judgment?
Yes, Your Excellency. It was in the Bosnian genocide where the Slaughterpact also asserts the past cases such as the Tadic case. Your Excellency, one clarification before this agent submit his first submission in regards to the monetary necessity. Your Excellency, while we are not denying that the respondent rely only on a circumstantial evidence, however, recalling this court judgment in the Corfu Channel case, where the court accepted the use of circumstantial evidence as long as these two conditions are satisfied. That first, the concrete evidence is only available or under the sole authority of the opposing party, and secondly, the circumstantial evidence cannot contradict with the agreed facts. In the present case, the concrete evidence which is the medical information, is only available in the data center, which is built and operated in the applicant territory, or meaning that the concrete evidence is under the sole or the exclusive control of the applicant, which means that which render impossible for the respondent to have such concrete evidence before launching the attack. Secondly, the which in the present case, the report of our truth does not contradict, even correspond to paragraph of the order, such as paragraph 36 and 39 of the order, where such paragraph express where the respondent saw less or the declining number of the returning troops of the respondent. And secondly, the existence of the website
actually confirmed or tried to confront the applicant, try to make sense out of what happened. Because I think it is unfair to allege what happened to their troops without any prior knowledge of what's actually going on in that centers, other than just suspicion allegation. Don't you think there should be a requirement of due warning?
Yes, we submit that an advance warning, Rule 20 of the Customary International Humanitarian Law, indeed requires an advance warning prior to the enactment of use of force. However, there is an exception.
It's a different rule, actually. It's Article 19 of the Fourth Geneva Convention. It's a prior warning given before you resort to, before the protection of a hospital ceases to exist. You only allege there has been conducted by the epicenters, but have you actually conducted due warning to force the epicenters to cease these alleged harmful acts?
Yes, even though the respondent does not or never conduct a due warning, however, it is all because it is important to understand that the due warning is not necessary or is not obliged. A state is not obliged to do an advance warning, warning prior to the attack if the element of surprise of the attack is essential to the success of the operation. In the present case,
do you have any state factors that could point to that strategy or any other authority?
Unfortunately, yes, this agent cannot provide the state practice that the court.
Okay, then let's go back to the previous case that you brought, which is the case of Corfu Channel. You've stated that circumstantial evidence can actually be brought into the court or be brought on the court. But my question to you, even in the case of Corfu Channel, the court actually double-checked with the expert in regards of the validity and the probative value of the circumstantial evidence. Don't you think in the present case, without that particular expert advisory, it actually affects the probative value of such statements or evidence?
Respectfully, in the Corfu Channel case, the standard that was used is that the circumstantial evidence should not leave any room for reasonable doubt. In the present case, our circumstantial evidence is corresponding to the two facts of the order, in which the existence of the website, which also supports the truth about the suspicious activities inside the
but that facts only come into appearance after the attack. Don't you think that the important information that you have to collect is something that is before the attack rather than the following facts that is found after the cyber attack?
Well, that is true, yes, however, in the present case, the respondent is impossible to obtain such concrete evidence, considering the availability of the concrete evidence is only under the exclusive control of the applicant. However, or the circumstantial evidence that the respondent have before the attack is part of 36 of the order, where the respondent saw less the declining number of the troops that is returning home. However, the cyber attack was also support because the circumstances around the attack is also amplifies the necessity of the respondent to enact such cyber attack. For example, given the fact that in contrast with the applicant, the respondent is much smaller nation. If I can direct you to the paragraph 2 of the order, the overall population of the respondent is only 1/3 of the applicant, which corresponds to the number of troops. And these smaller number of troops were also detained.
Also, due to the nature of the evidences, what does international law says about conditions of uncertainty?
Can you please reverse it?
Because there's a heavy contention on the evidence, and there's uncertainty here. What does international law says about situations of uncertainty? Can you still proceed with an attack?
Yes, I'll see. We submit that unfortunately this agent cannot provide you with a specific cases or a specific view of the court judgment that is will wholly support your question. However, we still submit that we rely on the standard of the what is brought in the corporate channel case, which is the circumstantial evidence should not leave any room for reasonable doubts. Yes, I'll see. In regards to the website itself, the applicant did not or never even contest the content or the truth or the information inside the website. Instead, yes, I'll see, they conducted an investigation. Yes, however, yes, I'll see, it is important to highlight.
They conducted the investigation because they got attacked. I mean, who in the right mind wouldn't conduct a investigation after people died in your country?
Well, that is true, yes, I'll see. However, it has to be highlighted that by the applicant themselves, and which constitute if they do the investigation to their own facility, which constitute the lack of impartiality.
I think you're misinterpreting the facts. I think the invest was conducted to find out where the virus originated, because neither the state nor the respondent state claims it, right? And of course, that particular how can you use evidence that you attacked to justify the attack?
Very well, you also see we are not using the facts or the circumstantial evidence that came after the attack. We're just confirming that the applicant did actually conduct such violation inside the data center. However, yes, even if the court
let's assume that the epicenter has become a military objective. But how could you justify the use of cyber attacks that could not distinguish whether it was trying to target a military objective or a civilian object or civilians? As I see, the purpose of the attack is only to retrieve information, but as a result, it infects way beyond that purpose. It resulted in a shutdown, even electricity shutdown. That's how can you wish targets using virus malware?
Very well, Yosansi. Firstly, Yosansi, we submit that an illegitimate collateral damage occurs when civilians are the sole and the exclusive target of the attack. In the present case, Yosansi, if this agent may draw your attention on paragraph 37 of the order, the data center server was the primary objective.
Before you continue, I apologize. You've stated that collateral damage, and you've stated that if the target was civilian, then it's not collateral damage anymore, no? Because collateral damage means that the civilian was not your intention to attack.
That is true, Yosansi. The civilian is not the main target of the attack. The main target was data center server, which was articulated in paragraph 37 of the order. Furthermore, yes,
I think, Counsel, what my distinguished colleague, Judge is trying to say is not about the target, but the nature of the weapon here. Because the court has confirmed in the past, especially in the nuclear, the threat and use of nuclear weapons advisory opinion, I believe, that much like nuclear weapons cannot distinguish civilians and combatants. Here, I think it's the same too. Don't you think, Counsel? Computer virus cannot distinguish which is a military object, which is civilians. You may have 1 minute to answer.
Okay. Yes, on C, we submit that there is the best measure prior to the enactment of such cyber attack. The respondent has taken 2 years in planning and executing the cyber attack in order to ensure the least casualties resulting from the cyber attack. However, the SLC
I can plan a nuclear attack for 3 years, and that does not make that nuclear weapons distinguish people and military object.
Very well. Yes, see, what this agent is trying to submit in the present case is that the respondent has tried to comply with the obligation of conduct that is proposed in the Article 57 of the first additional protocol. However, yes, see, even if the court finds that the respondent is liable of the death of the civilian who submit that the international humanitarian law itself does not ever prohibit the loss of civilian armed conflict. And I see that my time has elapsed. Can I have additional 1 minute, 30 seconds to conclude this intervention?
We have given you additional time. Just conclude, counsel.
Very well. Yes, see. Yes, see, to conclude this agent submission, we submit that the respondent has tried the best measure in regards to the cyber attack, and even if the loss of 2 civilian life is liable for the respondent, the international we still submit the loss of 2 civilian life is still a legitimate collateral damage. If the court has no additional question, this agent submission will be concluded, and we hope that the court will find in favor of the respondent. Thank you, and may it please the court.
Okay, thank you, counsel. Okay, and now rebuttals. Will the applicant exercise the right of rebuttal?
Mr. President, Your Excellencies, may it please the court. 2.9 rebuttals. First, the cyber attack is indiscriminate. According to Cloudflare Security, it clearly reflects as denial distribution of service, since it works by infecting the internet service that cause disruption to the system. Therefore, the cyber attack is indiscriminate because the server IC center used by civilian as life support system. And the second rebuttal, the respondent neglect their obligation as a state to prevent and responsible for the damage, along with a statement by Judge Ariel and Alex before the oil spill reached the high seas and the impact is international and no one's full with this, when actually they have an obligation of monitoring in the Article 5 draft articles on transboundary harm. Therefore, we allow hold responsibility for the oil spill incident. Thank you. May it please the court.
Thank you, counsel. Will the respondent exercise the right of rebuttal?
Yes, Your Excellencies. However, may I have 1 minute to draft my sub-rebuttals?
Please deliver your rebuttals. That's all.
Madam President, Your Excellencies, 2 points of rebuttals. First, regarding Claim 1, the respondent state submits that they have fulfilled the obligation to prevent transboundary harm and contests the obligation to conduct an EIA brought by the applicant. Your Excellencies, pursuant to Principle 17 of the Rio Declaration, an EIA is a national instrument and it's subject to the decision of a competent national authority. Therefore, in regards to how often RIA conducts its EIA, it's up to their national law. Furthermore, Your Excellencies, regarding Claim 2, Your Excellencies, in the 2011 Maruo-Shimana case, an illegitimate collateral damage occurs when civilians are the sole target of the attack. In the present case, the cyber attack specifically targeted the Alpha Center servers and not the civilian, highlighting the loss of 2 civilians were only collateral damage, which justifies such collateral damage in contrast to a bigger military advantage. Your Excellencies, this agent has finished her rebuttals and hopes that the court will be in favor of the respondent. Thank you, and it please the court.
Thank you, counsel. Bailiff, I believe it's time for feedbacks now, is it?
Yes. Do we do the first or feedback first?
The oral session has ended. The judges will now deliberate in the judges' lounge.
Or do we give
you give feedback later after the deliberation.
Okay.
Thank you.
Thank
Where do we
you.
move? Which chamber?
In the judges' lounge.